USCIS just recently published some additional clarification and guidance regarding the $100,000 H-1B fee, so let's talk about it. They provided some clarification regarding who is not subject to this $100,000 fee. So people who are currently in the United States and they are doing a change of status, an amendment, or an extension, they are not subject to the $100,000 fee if they're able to remain in the US for the process and not have to leave the US in order to get an H-1B visa. Common change of status applications typically come from those who are in F1 student status, and then they apply to do a change of status to an H-1B. So for those individuals, they will not be subject to the $100,000 fee, assuming that they are able to do so in the United States. So for those who are in the United States and their change of status applications, extensions, or amendments are approved, and they get approved for H-1B status, they are eligible to travel abroad to then get the H-1B visa to re-enter the US without having to pay the fee. I do want to make a very important clarification here, and that is if a person does file an H-1B petition and for some reason USCIS is not able to approve them for H-1B status in the United States and they actually have to travel outside of the US in order to be approved for an H-1B, those individuals would be subject to that $100,000 fee. The guidance did not say anything about change of employer petitions filed in the United States. So if you have an H-1B and you are wanting to move to a different employer and that employer is willing to file the change of employer H-1B petition for you, again, without you having to leave the United States, it's not clear if that $100,000 fee will apply. Now, in cases where the $100,000 fee does apply, it has to be paid prior to submitting the H-1B petition, and proof of that payment would have to be submitted with the H-1B petition. And it's not clear if the H-1B is ultimately denied, if that $100,000 fee will be refunded. Now, for employers who think they qualify under the national interest exception where they would not be subject to this $100,000 fee, they would need to send the request along with supporting evidence to DHS. The guidance did say that these exceptions will be granted in extraordinarily rare circumstances. So that tells me that it's going to be a pretty high threshold for employers to meet this exception. Current H-1B workers and their employers should review their current circumstances and any travel plans very carefully, and I would suggest talking to an immigration attorney before travel plans are made, just in case. So if you have any questions about your case, you can schedule a consultation through the link in my bio or by calling my office, and that information is also in my bio.